Welcome to Brief Encounters. This is our second episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong Teasdale, and I'm also the leader of the firm's Securities Regulation and Litigation practice. And with me is William Nelson, an Associate General Counsel at the Investment Advisor Association. So, hey, William, we are trying to cover all things standard of care in about a half hour today.
It's a tall order, Valerie, but I think we can do it. I know we're going to stay pretty high level. There's so much to unpack, and it's been such just an ongoing process going back, decades even. So I think let's try to tackle it and give our viewers some useful information.
Absolutely. So when we kicked off this podcast series a few weeks ago, we were really looking at how has securities regulation and enforcement changed since the Dodd-Frank Act? Let's pick that as a starting point for all things standard of care. And by that, I mean Section 913 of the Dodd-Frank Act, which was the legislation's attempt to raise the standard of care for broker-dealers. And I think you remember at the time, William, we were both following this legislation in different roles in our professional lives. And that was Section 913 had a lot of changes through the legislative process.
Yeah, absolutely, Valerie. Yeah, and it's funny because I recall, interestingly, working with you on these issues in our different capacities at the time. But, I think that there was a real concern within the industry, but also in Congress, that investors were, basically kind of confused, especially, retail investors about, hey, if I'm working with an investment advisor, or maybe I'm working with a broker dealer, or even if I'm working with someone that happens to both be an investment advisor and broker dealer, what kind of care am I getting, right? What kind of standard are they being held to, especially when they're giving that personalized advice? I think that was a real starting point. And, I know a lot of what we talk about in this podcast relates back to investor protection. And I think that's really what they were driving at here is that, hey, when you as a retail investor go to a financial professional, you should basically know what you're going to get as far as the duty that's owed to you.
I think that's right. And then there was also at the time survey efforts that showed that no matter which type of financial professional an investor was going to, the investor believed that that financial professional had their best interest. So there was also just sort of this larger confusion around the differences between a broker, an investment advisor, an insurance advice, and so forth. So Dodd-Frank was finalized in 2010, and with it was where Section 913 landed, which was very much known as kind of like a stitched together provision because it was very broad and spoke to giving the SEC authority to raise the standard of care for broker dealers, but then also gave some very specific exemptions. And the first thing that 913 also mandated was a study by the SEC that had to be completed within 6 months. And that study was released in January of 2011.
Yeah, and the study, is very interesting to look at when you go back because again, they really try to address this issue of, despite this extensive regulation, on the broker dealer side, you have the Exchange Act, on the investment advisor side, you have the Advisers Act. And basically, again, just the retail customers, even though they may expect to receive advice in their best interests, the regulations didn't necessarily match up with that view. And I think that going back to the study, what it really recommended was that the SEC should exercise its rulemaking authority for what they called this uniform fiduciary standard of conduct for broker dealers and investment advisors. And this is something that's been debated basically ever since the study came out, right? What is so-called uniform fiduciary duty? And I know, Valerie, you'll think back to how many times we heard the word harmonization as well when it comes to the standards of conduct. So yeah, I think that it was one of those things where the study, I think, brought some clarity, but just also produced additional questions to answer.
I think that's exactly right. And the study also pointed to a really tough question at the time, which ultimately regulation best interest sidestepped. But without getting ahead of ourselves, when we look at the 2011 study and just the language of Section 913, there was this discussion of raising the broker dealer standard of care to a standard equivalent or no lower than the Advisers Act fiduciary duty, which then the logical next question at the time in the policy debate was, well, what does that mean for Advisers Act case law? Is it immediately transferred over to the broker dealer standard of care? And I think that was a question that was a really big part of the discussion, but basically right after the study came out and all through the years until Reg BI was proposed in 2018. And that was kind of a sticking point, right? The idea of, well, how can you take Advisors Act case law and just sort of transfer it over to broker dealers? And I know both TM and IM staff had a lot of discussions about it over the years, and they were very candid on industry panels and so forth that that was something that was being looked at. So after the study was released in January of 2011, the next sort of big milestone was the SEC in 2013 putting out what was essentially a concept release about the duties of brokers, dealers, and investment advisors. And it was a more in-depth set of questions following up on the study, but not actually kicking off a rulemaking. It was more just collecting additional industry perspectives, additional industry comments. And I remember that comment file being very robust and really starting with the statutory language in 913 and the 913 study and really sort of putting up multiple straw men. So different trade associations and different industry firms were putting up essentially, this is what this could look like type of comment letters. How could the broker dealer standard of care be raised? What could be done I remember there was one letter that talked about, well, let's take the FINRA rule and let's rewrite it and raise the broker dealer standard of care that way, which was an interesting approach considering the discretionary mandate was given to the SEC to do that. So I think looking back now that we do have Reg BI in 2024 and it's been implemented for 4 years, it's interesting to see all of the different strands of suggestions and concepts that were raised between 2011 and 2013.
Yeah, Valerie, and that's absolutely right. And I think your point about kind of looking at how the current guidance at the time and also the case law for advisors would be applicable to broker dealers, because I think it's interesting sometimes when you talk to folks who maybe aren't as steeped in these issues as you and I are, they're like, well, of course, advisors have a fiduciary duty. But interestingly, when you look at the Advisers Act, the fiduciary word's nowhere to be found. Even though, back in 1940, when it was passed by Congress, the SEC's fiduciary duty for advisors really came out of Supreme Court decisions in the 1960s. So I think that was a really big sticking point saying, look, this has really been defined. And what, normally a lot of times we'll talk about at the IA is this, what we call this principles-based fiduciary instead of very, granular rules-based, which a lot of the, the FINRA rules that govern broker dealers, again, we would say are more rules-based, and the fiduciary duty, which is meant to evolve over time, and that can be seen through those Supreme Court decisions, is really more principles-based. So I think that was a really kind of a real struggle, I think, for the SEC, and maybe that's a good lead into why it ended up the way it did with regulation best interest and the fiduciary interp in 2019. But I think that was really a struggle for them, kind of saying, hey, we have this mandate from Congress. We've done this study. Kind of how do we look at how we kind of match up these different standards of care for advisors and broker dealers? And, do we bring one up and one down to meet in the middle? Do we bring both up to the same level? So I think that was really a struggle for the staff.
I think that's right. And, we're saving DOL ERISA rulemakings for the end of the episode. But the other thing that was happening alongside the SEC staff considering a potential rule proposal and working on it, between 2013 and the actual Reg BI proposal in 2018, was that the DOL, alongside of that, was in the process of proposing and ultimately adopting a fiduciary rule expanding the scope of ERISA. So that was also happening alongside what I'm going to call sort of the SEC considering the 2013 concept release comments. And then we fast forward to 2017 when then SEC Chair Clayton became chair. And he was very forthright from the beginning of his tenure in 2017 that he wanted to really sort of provide resolution to this ongoing debate of a broker dealer standard of care becoming higher and how would that happen. So I remember, one of his initial set of remarks really telegraphed very strongly that that was something he wanted the staff to look at and to come to a decision point on. So we knew in 2017 that that was very much in the works in terms of a broker dealer standard of care proposal. Nobody really knew what it was going to look like, particularly because some of the sticking points had been Advisers Act case law, the fact that industry commenters rightfully were pointing out that broker dealer advice tends to be very episodic. It's not an ongoing relationship. And sort of fast forward to spring of 2018, in April of that year, when the SEC put out for comment what is now known as regulation best interest. And looking back, it's kind of amazing to me because we're in June 2024 at this point, and it's been 6+ years since we've been working through that language, both at the proposal level and then the ultimate adopted version in June of 2019. But it's always interesting to me how quickly it evolved, right? So we went from in 2011 and 2013 having discussions of how can this be done? How can the statute be incorporated into the rule? Because one of the issues with 913 was that it was a very tough statute to thread a needle around to have a rule. And then, come 2018, the proposal looked fairly close to what it ended up being. There's some key changes. One of them is that the proposal had 3 obligations and the final had 4 obligations. Of course, the final 4 obligations are disclosure, care, conflict, and compliance. And the compliance obligation was the one that was added as a result of, frankly, investor protection stakeholder comments pointing out that Reg BI needed an equivalent mechanism to Advisers Act Rule 20647, which is the compliance rule.
Yeah, absolutely. And I really agree with you on the speed issue because I think that it was kind of being slow walked. You had the 2011 study, you had the 2013 concept release, request for comment. But I think your point also about, I think a lot of industry really, even though they were on parallel tracks, I think there was a lot of industry interest in the ERISA fiduciary rulemaking as well. The proposal in 2015, the final rulemaking in 2016. Ultimately, it was overturned by the courts in 2018, and I can discuss the more recent ERISA fiduciary proposal a little bit later. But yeah, I think that there was kind of this lull over these few years when we kind of moved over to, hey, this Department of Labor, this other government agency is imposing this fiduciary duty on us relating to retirement plans and also individual retirement accounts, IRAs. So I think that kind of sucked up a lot of the oxygen. And then once, the 2018 period, the case was, ultimately the rule was overturned by the courts. And then in comes Chair Clayton is like, look, we're going to get this done, right? This is what we're going to do. And I completely agree on the speed. And along with the regulation best interest for broker dealers, the SEC also put out what we now refer to as the 2019 Fiduciary Interpretation. So basically, looking back over the history of the cases, there wasn't really any kind of specific interpretation of what the fiduciary meant, at least from the SEC's perspective. Again, It was mostly, facts and circumstances, act in your client's best interest. But, the 2019 interp really put some meat on the bones on what advisors should be doing. Now, again, we would say that sometimes it tended to get somewhat granular, especially related to the duty of care obligation. I think that historically, I think advisors were very comfortable with the duty of loyalty. Of course, I'm not going to subordinate my client's interest to my own. I'm going to make full and fair disclosure, have informed consent for any of those, most material conflicts. But then they really kind of dug in to this duty of care. At all times, you have to serve the best interest of your client based on their objectives. And yeah, they also included the advice and monitoring over the course relationship, which again is, a lot of what separates, as you said, Valerie, the advisor from the broker dealer, that more kind of transactional advice versus the relationship based advice. But I think this is really where we saw the SEC really diving in and saying, hey, advisors, here's kind of what we think the duty of care means, and we'll give you some examples of what informed consent may look like, and when do you have a reasonable belief that your advice is in the best interest of the client. So I think that was really a really big switch for the industry, when historically I think we were a lot more focused on that duty of loyalty, the not subordinating the interest, but then moving into the this whole area of this duty of care.
I think that's exactly right, especially if we look at the package of proposals in 2018, which was Regulation Best Interest, Form CRS, the Advisers Act, and TERP. It was sort of a three-part package, right?
Mhm.
And the Advisers Act and TERP proposed in 2018 and adopted in 2019 as part of the larger Regulation Best Interest package. The interp did not move much. It was very similar in terms of what was proposed and what was adopted. And it purported to not make any new Advisors Act jurisprudence or interpretation, but rather pull into one place a lot of the existing jurisprudence and existing interpretations and existing expectations, so to speak. In contrast, Reg BI evolved pretty quickly through right about a year of comments and added the compliance obligation. Reg BI also refined the care obligation, which was a pretty strong cornerstone of both the proposal and the final Reg BI adopting release. And to your point, looking ahead, I think the staff made sure that the duty of care component of the Advisors Act interpretation, or the fiduciary duty interpretation, was also similarly robust.
Yeah, absolutely. And I think, this kind of goes into some of the more recent SEC staff bulletins, I know we're going to talk about, but I think it's something that we've at the IA been concerned with, is this kind of these merging of the two, right? So we have this Advisors Act principles-based robust fiduciary duty, but now we also have, the regulation best interest, duty of care for the broker dealers. And I think that's something that we've been a little bit concerned about, just looking over the past, 1, 2, 3, 4 years, is that, these are kind of being merged together, right? And even if you look at some of the bulletins, which we can talk about, basically they say that, hey, each of these standards is drawn from key fiduciary principles. So again, the same types of information, similar analysis, similar conclusions. But again, we think, even going back to 913, does this really assist those retail investors with, hey, when I work with someone, are they being truly held to the same standard, even though there might be components, especially if they're drawn from those certain principles. But I think that we are a little concerned that, based on some of the recent guidance from the SEC, that it could still be, causing the same type of confusion.
And that's right. And, applying the interp for a standalone registered investment advisor is also a little bit different than dual registrants, which I think is another area that the bulletins from 2022 and 2023 were trying to get at. Because what happened was Reg BI and the interp were adopted, as well as Form CRS and the solely incidental interpretation, were all adopted pretty much exactly 4 years ago in June of 2019. And there was a 1 year implementation period for Reg BI. But the interp had only a 2 month compliance deadline. And looking back at that time, the way dual registrants were implementing Reg BI was a little bit different than standalone broker dealers, and in turn was different from standalone registered investment advisors who were looking at the fiduciary interp and really seeing, well, how much daylight is there between this interp and what we've already been doing. Looking at the dual registrant piece, there was a real shift towards looking at how account recommendations were made and which standard of care would apply. Would it be Reg BI or would it be the Advisers Act standard of care? So there was that at play. But I think looking back, and I did a lot of Reg BI implementation in 2019 and 2020, as much as there was guidance in the adopting release and in some of the subsequent FAQs, there was a real appetite from the industry to have further guidance, which ultimately happened in 2022 and 2023 with those staff bulletins to which you're referring, William. But I think there was an element of firms still trying to work through how to have their account opening process really line up either to Reg BI or the Advisers Act and what made the most sense for their registrants, meaning their dual registered financial advisors and so forth.
Yeah, and Valerie, I think that's a terrific point, especially with the duly registered broker dealers, investment advisors, because I think historically there was a lot of criticism, especially from consumer groups, investor groups, that dual registrants may be engaging what they called hat switching, basically saying, hey, we're going to give you advice, but then we're going to take off our advice hat. And when we sell you the actual product, we'll have our broker dealer hat on. At the time, this was pre-Reg BI, that was just a suitability standard. So basically, hey, maybe fiduciary advice, but we just have to find a product that's suitable. That's basically, that's suitable for you based on your objectives, based on your profile. So I think there was a big push, especially in these staff bulletins. And I think they may even talk about specifically, hey, for duly registered investment advisor broker dealers, here's kind of, what we're going to expect of you when opening accounts, when looking at your conflicts. Because historically, I think there was this concern about this, what they call this hat switching, and potentially, again, going back to the investor protection issue, what standard are they being held to, but also what standard are they being held to at the time? Is it the time when the advice is provided, or is it the time when the recommendation is provided?
That's exactly right. And another thing that Reg BI sort of went to great pains to define were the obligations of the broker dealer versus the obligations of the associated persons of the broker dealer. So, for example, the care obligation applies to both the broker dealer and the individual associated person, whereas the compliance obligation applies to the broker dealer only at the firm level. And the conflict and disclosure obligations are largely at the firm level and are meant to replicate the same process that investment advisors do of surfacing conflicts, documenting conflicts, managing conflicts, and disclosing conflicts. But that's very much at the firm level under Reg BI. It's the care obligation, which gets right at the root of something like hat switching, which is how does the individual associated person meet the care obligation under Reg BI?
All great points, Valerie. And I think that's something that, has again also been a struggle looking at the registered person versus the firm and where those duties lie. And, I did have a question for you that we have this 2019 fiduciary interpretation. Reg BI, regulation best interest, has been in force for the past, 5-6 years. How have you seen kind of the enforcement evolve? I know we're starting to see, I think, more pure regulation best interest cases come out when previously, there was criticism that, hey, that would have been a violation under the previous standard, the suitability standard. What have you seen in your practice? I'd be curious to hear that.
So, we're discussing this right at the beginning of June 2024. And at this point, there's been a small handful of Reg BI cases that, like you said, would have occurred even under the suitability standard. Then there's been a second small handful of Reg BI cases that really speak to lack of implementation, and especially lack of thoughtful, demonstrated implementation. There was a third bucket of cases that were really focused on disclosure and the conflict obligation and the disclosure obligation. And then there's another set of settlements that I expect will really focus on the care obligation. The original one is, of course, the Western International litigation, which has very much focused on the care obligation, not just of the firm, but also of several associated persons. So Western International has, as of the date of this recording, not yet been settled. But the expectation is very much looking ahead to, the cases that I'm defending and just sort of more generally at the landscape. The next set of Reg BI cases will focus on the care obligation.
Yeah, I think that's really helpful. And I know, on the advisor side as well, I think we're still just seeing cases, failure to disclose conflicts, duty of care violations. Looking back, I think a lot of the cases in the advisory space, not, I think at the end of this episode, we can kind of talk about what we're seeing with the current rulemaking, how we see that really potentially changing how the SEC views advisors' fiduciary duties. But a lot of it really hasn't changed. Disclosing conflicts, informed consent for especially on the retail clients, the duty of care violations. I know we did see a rash of mutual fund share class cases. We haven't seen those, more recently. And what's interesting too, Valerie, is that I think that, looking at some of the cases, there is a concern of what some people are calling kind of that Monday morning quarterbacking, right? So, hey, of course, you're a fiduciary, you disclosed your conflicts, but when it gets to this duty of care, have you met it? Have you done enough? And is the SEC going to come in and say, look, well, show me what you've done, and we're going to determine whether you meet that duty of care, rather than the firm, proactively saying, hey, here's the documentation, here's the process, the prudent process I went through. So I think there is that concern as well coming out of a few of those cases, kind of, is the SEC going to be kind of doing that second look and really digging in on those kind of, more, honestly granular decisions?
No, I think that's right, William. And, the thing that I always remind both clients and SEC staff that I'm negotiating with on matters is there is language in the Reg BI adopting release that makes it very clear that the recommendation needs to be evaluated at the time of the recommendation, not with the benefit of hindsight. And that comes up 4 or 5 times in the adopting release. I think that's an important thing for all of us to remember, whether it's defense counsel, whether it's in-house counsel. It's very important to remember that the Reg BI standard is at the time of the recommendation. And of course, the Advisers Act duty of care is also sort of looked at through the lens of at the time of the advice and of the recommendation. The thing that I also wanted to highlight on the Advisers Act's enforcement side of things is we saw many, and by many I mean several dozen, duty of loyalty settlements and conflict of interest settlements, both as part of the share class shared disclosure initiative, but then just sort of more broadly, there was a real focus, and there continues to be a real focus on Advisers Act conflicts when it comes to enforcement investigations and settlements. Within sort of call it about 2 or 3 years into those settlements, the staff started pulling in an increasing number of duty of care case theories. And that's really what I have my eyes set on, because logically, if you've got SEC enforcement staff working under the direction of the care obligation needs to be a large part of Reg BI settlements, then by definition, there needs to be sort of that equivalent on the Advisers Act side of enforcement settlements. And I think we've been seeing that grow for a couple of years, even right after the adoption of Reg BI. When we look at some of the Advisers Act settlements at the time, there's increasing mentions of the duty of care, the concept of best execution within the duty of care. And so that's something I'm really focused on, both in terms of working with clients to future proof their compliance programs and their regulatory risk programs, but also at the beginning of any investigation that involves sort of a more general case theory from the staff and sort of a larger set of document requests is really to understand, is the staff looking at this through the duty of loyalty lens, or are they looking at this through the duty of care lens?
Yeah, I mean, those are great points. And I think your point too about this, what I call kind of the hindsight bias, is, previously having served as a chief compliance officer, I would tell my staff, like, look, you could give the best advice in the world and the market crashes the next day. Or you can give just terrible advice and the stock goes up 100% or 200%. It's interesting because it does align to, I know we talked a little bit about it earlier, the RISA fiduciary duty as well. Their duty of care is basically what they call the prudent person standard, at the time with the same care and skill and diligence under the circumstances. So again, they are always going to be looking at that prudent process rather than any kind of result of the advice. So, but I think there is always that concern of, what I call hindsight bias. I know we're getting to the end of the episode today. So, I did want to end with what we see going forward. Where do we see, standards of conduct going? A lot of the SEC rulemaking proposals out right now, can potentially change how, both the SEC and the industry looks at how the fiduciary duty is implemented. So, Valerie, I'll let you go first. Just kind of what you see going forward, both with the current SEC rulemaking proposals, but also just kind of, reading the tea leaves.
Now, of course, and there's a lot of tea leaves to read with standards of care because, of course, it's not just about Reg BI and Advisers Act fiduciary duty. There's also ERISA developments, which I'll let you speak to, William. But I wanted to just spend a few seconds touching on state developments as well. So, obviously, the Massachusetts fiduciary rule has been in place since early 2020 and has survived litigation at this point. And the Massachusetts Securities Division is well into enforcing the rule. There's a current ongoing suit. And then separately from that, there's also the statute in Nevada where rulemaking has still been pending for several years. And then finally, there is the NASA proposal for broker dealer standard of care that is meant to align to Reg BI, although industry commenters, and full disclosure, that includes me, have been very forthright that the current NASA proposal does not align with Reg BI and would be unworkable if adopted as proposed. So, in terms of the tea leaves, there's the fact that Reg BI enforcement is going to continue and, frankly, accelerate in the next 6 months or so. And then Advisers Act enforcement will also continue. But then there's also the state component in terms of Massachusetts fiduciary cases and then this NASA rulemaking and what could happen there. There's also the NAIC model, which has been in place for several years at this point and has been adopted by over 24 states that has a Reg BI safe harbor, so to speak. So those things all influence how firms build their standard of care compliance programs. And they're very sort of business model specific at the end of the day. But William, what are you seeing in terms of tea leaves, and where do you see this latest iteration of the ERISA fiduciary rule fitting in?
Yeah, that's always an interesting question because at this point it's their fiduciary rule 4.0. It did become final recently. It is already currently under litigation, mostly from insurance groups that are opposing the rule. I think that at least from the rule release and the public comments, I think they really did try to implement the new rule based on the 2018 court decision, which overturned the previous rule. So I think they really did take, great pains to say, look, we're aware of this 2018 court holding on our previous rule. Here's how we believe that our new rule would not violate those same principles. So I think they really did try to, kind of meet those requirements in the 2018 rule, looking at whether or not you're a trusted advisor, even if maybe you are providing one-time advice, but still having that safe harbor for what they're calling a sales pitch. If we're just selling a product and, obviously, we're just a salesperson and, we're not that person's advisor. So I think at least, initially, again, we'll have to see how the litigation shakes out. But I think initially, I think they did take great pains to kind of enact a rule that would meet those previous requirements set by the court. I think on the SEC side for advisors, one of the things we've been concerned about is potentially, changing the fiduciary duty for advisors based on the technology that's being used. And, hopefully at one point we'll get to talk about AI on the podcast. But I think that the SEC's recent proposal for what they call predictive data analytics, basically, these emerging technologies, how they're being used with investors, could fundamentally change how the fiduciary duty is looked at through the lens of technology. And, I think that the SEC realized the impact it could have on the industry, and they just recently announced that they were likely going to repropose that rule because of the pushback they've received from, the industry as a whole. But I think that's one thing, reading the tea leaves, I think that we're looking at and focused on is, we have this principles-based fiduciary duty that's been around, since 1940, interpreted by the courts in the 60s, that we do believe is principles-based and can evolve and can be adapted to meet these new technologies. But that's definitely something we're keeping an eye on, is how the standard of care and the duty of loyalty interact with this new technology, such as artificial intelligence and other emerging technologies.
I think that's exactly right, William, especially because regulators and especially the SEC are very focused on bias. And the concern, obviously, with standards of care is what are the biases and undisclosed conflicts. And now when you layer on technology, it's, well, are these biases human created or are they created by the algorithm? And are those disclosed to investors?
Exactly, Valerie. You don't know what you don't know. And, in this world of emerging technologies, artificial intelligence, large language models, I think it is kind of the new frontier. And I think that we are going to have to keep on top of it and kind of see how this type of technology is being implemented, at least with respect, especially to retail investors.
No, I think that's exactly right. And, the reality of standards of care discussions is at this point, there's such an element of handling with care, because as you pull one strand on sort of one side of the discussion, it can have a ripple effect.
Absolutely. I think we've done a great job keeping it in the time limit, but I agree, this is such a complex area and there's so many nuances to, each of these. So I think it's important for folks to just, really remember these standards of conduct are always going to be, very highly factual determinations, but based on kind of the high level summary today, it should really show people, there are, so many different views and different nuances you have to be aware of.
No, I think that's exactly right. And at some point later this year, we should revisit regulation best interest enforcement developments when there's more of them out there. But I think we're well over our time, William, so we should probably wrap up. Thank you again for co-hosting this podcast with me. Till next time.